Hello, everyone. This is us back again, episode 23, and we are ecstatic. That's a good word to use to welcome Konstantina here today with us. Welcome to AI in Real Life. We're so happy to have you. And we're going to be talking about very exciting stuff. Please, in a few words, Konstantina, tell us about yourself and I don't know, whatever you want people to know, just
Of
briefly.
course. I should start by saying a big thank you for the invitation. I'm really excited to be here with you. And before I introduce myself, I think I need to commend you on the initiative to start this podcast, which is a source of inspiration and it's also a source of knowledge. So, first of all, I'm very honored to be here with you today. And secondly, I cannot, you know, overstate the importance of this initiative and having two women lead this. So, I'm really happy to be here. Now, if I had to introduce myself, I would say that I'm currently a partner, Geradan Partners. This is a law firm that specializes in competition law and digital regulation. And the areas that I have been primarily working on are platform regulation and competition law in digital markets. And we'll talk about that in a bit. I also teach competition law. So I started off my career as a competition lawyer. But then, as things would advance, I jumped into media regulation, especially online media regulation, and gradually platform regulation, because this has become a big thing in the EU, and I will explain why. So, over the past 20 years or so, I have been working in three different areas: competition law, media regulation, and more recently, platform regulation. And this is also the area where I did my PhD and the area where I have been teaching for the past 10 years or so.
Konstantina, thank you so much. I'm definitely looking forward to get educated on competition law and digital regulation. And thank you for joining us. And thank you for for such a nice intro. Elena and I are trying to talk about real life implications of AI technologies and other tech that are kind of adjacent to AI as well. And I think this is what we'll be talking about today. And I just wanted to kind of show our audiences what we'll be centering our discussion today around. So, as you mentioned, we will talk about what online platform regulation is at the first place, right? And then we'll talk about digital markets a little bit and kind of that dichotomy or not with the freedom of expression when we're regulating content and devices. And last but not least, I mean, this is AI talk, right? So I think we will switch to regulating of generative AI content and kind of discuss some of the implications that are happening right now. So yeah, this is kind of our structure today, but we might digress. And live audiences,
We will.
please ask questions. Thank you, Elena.
Elena
This is
has
always a
prepared.
disclaimer. Yeah, and please ask questions in real time. We'll try to address them. Have Konstantina maybe as well answer them as we go. But if we don't, if we have all these questions at the end, they will be all posted on YouTube and also on LinkedIn so that we can answer them if we can to the best of our knowledge, maybe at the conclusion of the talk as well. So without further ado, I will pass the baton to Konstantina and off we go.
Of course. So, first of all, many thanks for preparing this very useful slide, Alisa. I should start by trying to put things in perspective in the sense that I will try to explain because I understand that your audiences may not necessarily be based in the EU, and therefore they may not have a clear idea of what is going on here. And I'm saying the EU because this is the jurisdiction that spearheaded platform regulation in many different ways. I will explain why in a bit. But I think that it's important to understand how we got here in the sense that, in my view at least, it's not because the EU likes to regulate, it's because we had a huge gap in the existing regulatory legal framework, and therefore we decided to do something about it. And therefore, I want to explain why we decided to do something about it and how we went about it. The how we went about it, I will explain by reference to two different streams of regulation. The first one is regulation of digital markets. And the second one is the regulation of content, so essentially content moderation. Why am I making this distinction? I think this distinction is useful because we have so many different instruments that we'll talk about today, or at least touch upon, because we cannot exhaust everything in 1 hour, that I think it's useful for the audience to understand a little bit on the category under which instrument falls. So just by means of introduction, I think that many people heard about the Digital Markets Act, or DMA, the Digital Services Act, or the DSA, the AI Act, definitely, especially through your podcast, the Data Act, competition law or antitrust law in the US. So when we talk about the regulation of digital markets, I will primarily refer to competition law, antitrust law, the DMA, and the platform to business regulation. When we talk about the regulation of content, I will primarily refer to the DSA, or Digital Services Act, and the European Media Act, and many other initiatives that follow suit at the national level, at the member states level. So that's basically to put things in perspective. Now, of course, we will also talk about the regulation of generative AI. And when I say regulation of generative AI, I think it's important to take a step back and consider that we not only have the AI Act at the moment, we have so many other rules that apply to generative AI, and those include horizontal rules that have always applied to all technologies. For example, consumer protection regulation, competition law. So we have some rules in place for generative AI as a technology or application thereof. And on top of that, we have some sector-specific rules that seek to regulate that specific technology or application thereof. Okay? So moving on to the introductory part, how did we get here? Is it because Europe likes to regulate? And I've partly given away my answer to this question, but I'm happy to get objections to what I'm about to say. I think that it's important to take a step back and go perhaps, how many years back? Perhaps 10, 15. There was no such thing as platform regulation at the time. This has emerged as a new legal subdiscipline, right? But we did have horizontal rules. We had competition law or antitrust law. We definitely had consumer protection regulation. And we had some transparency, loosely drafted rules on content moderation. So essentially, we had very specific rules, and I say specific rules that were very much adapted to the specificities of the brick and mortar world, but rules that didn't necessarily address the concerns posed by online platforms or more broadly digital technologies. However, we know, and I'm referring to the safe harbor rule with respect to content, where, platforms are not liable for the content they host unless they become familiar with the fact that illegal content is being disseminated on the platform, and then they need to remove it. And they will be liable if they become aware and they don't remove it. So that's basically the case in the US, and up until recently, that was the case in the EU, the so-called safe harbor provision in the EU in the e-commerce directive. But as things advanced, as things progressed, platforms started to play a quite prominent role in our daily lives because they not only host content, they organize content, they rank content, they edit content, they moderate content, they do all those different things. And we started to realize that platforms, not only host content, but they can actually determine the quality and the variety of the services and products and content that we access and engage with. And I'm not only referring, to platforms where one can go and book a flight. I'm actually also referring to platforms that disseminate news, that can determine the election results that we participate in. So it became very clear to legislators in Europe, both at the EU level but also at the national level, that there was a big gap in the legal framework, that, existing rules, horizontal rules, were not appropriate to address the challenges posed by digital platforms, but also that we didn't have enough or robust enough sector-specific rules, just the safe harbor rule in the e-commerce directive. And therefore, at some point, it became clear that we had to do something about it. At the EU level, I think that this process of reform started with a very ambitious competition directorate or directorate for competition with Margrethe Vestager as the EU commissioner. So you may know that Margrethe Vestager for many years led DG competition, or the Commission's competition service, and they basically decided to start some big and controversial cases against big platforms, including Google, Apple, Amazon, and so on. So what we realized is that up until those cases, investigations were opened, we had a very narrow-minded approach to the enforcement of antitrust rules in digital markets. Let me give you an example. For many years, going back to the era of, and many younger people may not even understand what I'm talking about, of free-to-air television, linear television. So in those days, the European Commission, which enforces the EU competition rules, would say, well, if the viewers do not pay for content, there is no price, therefore there is no market to define, and therefore we will not be assessing this any further. And to some extent, the same approach was followed in digital markets or in competition law enforcement in digital markets in the early days. We would say, well, online search, this is offered for free. There's no market to define. We don't find any problems here. But then we realized that this actually misses the mark, because even though we don't necessarily pay for the service, that does not mean that there is no market and that there are no problems in the market that is affected by the practices of, for example, an online search engine. So we definitely saw a shift. In my view, the case that was the paradigm shift was Google Shopping. I'm sure you all heard about it. It concerns how Google ranks specific products or services. So basically, the case was about Google granting preferential treatment to its own Google Shopping service, price comparison service, whilst demoting competing services, competing price comparison websites. So in that case, going back to my example of services offered for free, the Commission said, well, even though users do not pay for the service, they actually do pay with their data, with the data they provide to Google. Therefore, the relevant market here is the market for search results, and the end users exchange data for search results. And since then, we saw a tsunami of decisions addressing not only price-based practices, price-based parameters, but also non-monetary harm, right? So we saw this with the recent Apple decision on anti-steering restrictions. We saw that with the decision on Amazon that concerned, perhaps some background here, many of you will know that Amazon is the e-commerce marketplace that most of us use to buy things, but Amazon is also a retailer. And therefore, what happened with the EU case is that the European Commission took issue with the fact that Amazon was extracting data from third-party retailers to enhance its own retail offering. So basically, that's not a price-based case. That's the theory of harm, as we say in competition law terms, was primarily based on the use of data by Amazon and how it was using the market power or the dominant position, monopoly position in e-commerce to basically enhance its own retail offering. So we saw a tsunami of decisions in competition law, antitrust law, which are very, very, very interesting. And I would highly recommend that you read through some of the press releases or decisions if you have more time. That would be about competition law. We also saw a big reform in terms of consumer protection regulation. And, as I said, consumer protection regulation was very old-fashioned, very traditional. We would focus on practices that would affect consumers that would go to the supermarket and buy something, or would, watch a misleading advertising spot on television. That's not the case anymore. The rules have been reformed in the EU, but also in the UK more recently. And we have some practices that are prohibited, for example, fake reviews in the UK. Or in the case of the EU, e-commerce marketplaces need to, for example, explain, or search engines in our example, need to explain that, a product may have been ranked first because somebody paid for that ranking. So we have more transparency obligations to protect consumers. So we see this process of reform. And of course, when I talk about competition law and consumer protection regulation, these are horizontal rules that had to be reformed to address the challenges posed by online platforms and more generally the increasing use of digital technologies. but as a separate reform process that is, of course, linked to the other reform process of horizontal rules, we saw the adoption or revision of sector-specific rules, meaning rules that primarily targeted digital technologies. So I refer to the e-commerce directive and the safe harbor rule. That basically became a part of the Digital Services Act now. But the Digital Services Act not only has the safe harbor provision, it also establishes a lot of obligations with respect to content moderation, transparency vis-a-vis end users, more stricter obligations for very large online platforms, which we also call VLOPs, in terms of risk management, how they address the systemic risks on their platforms. So we not only have the safe harbor anymore, but we have these other obligations, newly established obligations, in terms of increased transparency, content moderation, notice and takedown mechanisms, essentially, and of course, for very large online platforms and very large online search engines, additional rules to address risks, systemic risks. So this is basically how we got here. We understood that, in a nutshell, we understood that the legal framework had a very big gap, and that the digital technologies, the use of digital technologies was only expected to increase and definitely not decrease. And we thought that it was a good idea to start regulating online platforms based on the experience of competition law enforcement. One thing that I should mention is that when we discuss, these big cases, you may have seen, fines in the billions against Google, against Apple. We need to remember that these cases, the antitrust cases I'm referring to, only apply to the company under investigation and only in relation to the practices that are investigated. And therefore, competition law or big consumer protection cases against specific platforms have a narrow scope of application. Whereas ex ante regulation, meaning regulatory rules that apply without ex post enforcement, meaning there is an obligation and we need to comply with it in advance. And this is how we design our products or our global our EU offering. These rules establish a standard. Everybody needs to comply with it. We do not need a decision that will only apply to one company. That does not necessarily introduce an industry-wide standard. So this is basically how we got here. Now, one thing that I have to mention in relation to all these regulations, I'm clearly a platform regulation proponent, but I am concerned about a couple of things. One thing that I'm concerned about is whether, the obligations, these newly established obligations and prohibitions will actually be effective in terms of how they are designed. Some of them are very loosely drafted, and I'm fairly certain that very big platforms will try to take advantage of this vague wording of these obligations. And the other thing that I'm a bit concerned about, actually very concerned about, is enforcement. So basically, that we have this massive wave of regulation, but who is going to enforce these rules? At the EU level, we know it's going to be the European Commission that will be enforcing the Digital Markets Act and the Digital Services Act. Then at the national level, some regulators, for example, media regulators, will be monitoring compliance with obligations imposed on YouTube, for example, in relation to media related aspects and other aspects. But I'm not entirely sure whether the European Commission or national regulators have the financial resources they need to basically go against big tech, whether they have the technical expertise that is required, and in many cases, whether they even have the political support that is required to pursue these very difficult and controversial cases. So, I will conclude the introductory section and perhaps open the floor for your questions, if any, with these remarks.
Yeah, Konstantina, I wanted you, because you're talking about the UK framework as well as European Union, and I just wanted for our audiences, so you kind of make clear that there's two separate legal systems, right? Maybe I'm preaching to the choir and just kind of stating the obvious, but I think when we're talking about cases and precedents, something that in the common law system like the US and UK, the case is being decided kind of, and if and then if the appellate court decision, you will have the it will be the precedent for the lower courts to follow and things like that. So, but in the European Union, the situation is different, right? So whenever there's a court decision, it doesn't have, it doesn't have the it's not a precedent for for the lower courts to follow. So basically, because the legal system is different, so we have all these regulations, right? And then the courts, they interpret the laws, but the judicial decisions, they're not the rule of law per se. And this is something that I think also speaks towards enforcement. Like we have all these big cases coming out right now, but I think the outcome might be different. I just wanted to kind of to hear your perspective on that.
Absolutely, Alyssa, this is an excellent
regime
question.
is so different. Yeah.
Yes, no, absolutely. And, I should start by saying, guys, Europe is big. And with Brexit, it's bigger in the sense that we have, one more jurisdiction, in the sense that, let me start from what the UK has been doing and the implications of Brexit for the rules that we are discussing in this session. So with Brexit, the UK is not bound by the precedent created by the Court of Justice of the EU. Moreover, the competition authority, the CMA here, is not necessarily bound by what the European Commission has to say with respect to an investigation. So clearly, the Competition and Markets Authority in the UK has much more freedom than it used to have. Why? Because in the past, when the UK was part of the EU, the CMA and, of course, other regulators, agencies in the UK were bound by the so-called duty of sincere cooperation, which means that you cannot do as you please. You have to take into account the broader picture. And if the European Commission decided that an investigation or a practice that it wanted to investigate had cross-border effects, it affected trade within the EU, it would basically be primarily responsible for the case. And then national competition authorities, including, for example, the CMA, would stop proceedings, and then the European Commission would take over. That no longer exists. And another testament to that, to the fact that we are talking about two completely different jurisdictions, is that the UK has recently adopted the DMA equivalent, the so-called DMCC Act. Okay? The DMCC Act is basically, or tries to regulate both digital markets, in the sense that it tries to regulate platform to business relations, but also platform to consumer relations. So it doesn't only regulate the relationship between businesses and platforms, which is primarily what the DMA does, but it also includes consumer protection rules within the Act. Okay? So that's about the UK, which has now its own regime. Of course, things are very recent. The DMCC Act has only recently become law, which means that we are expecting to see a very interesting line of case law in the UK. With respect to what you said about the Court of Justice of the EU, the Court of Justice of the EU, with respect to matters that have to do with the interpretation of EU law, is the ultimate arbiter, and national courts need to follow the precedent of the Court of Justice of the EU. However, and this is a big however, when we talk about the DSA, the DMA, the AI Act, the Media Freedom Act, these are all regulations, which means in practice that they directly apply at the national level. We do not need an act of transposition, say a decree, for example, that transposes the regulation into national law. Therefore, if I'm an app developer, just to put it very simply, if I'm an app developer and I'm affected by a practice of a big app store, I can immediately go before the national court and basically make my case. Okay? Which means that the national court has the opportunity to interpret the regulation as it deems fit, depending or given the circumstances of the case. And therefore, there will be cases that will eventually reach the Court of Justice of the EU that will decide on matters of interpretation. But many of these cases, is my take, will be decided by national courts and in some cases national regulators. And therefore, Alyssa, you're absolutely right. We will see discrepancies across the EU. We expect the EU to be a patchwork. I do not expect to see by any means complete harmonization when it comes to the interpretation and enforcement of these rules.
I just
Thank you so much for
Obviously.
explaining that, because I mean, European legal system is such a it's a very complex system, as you were saying. I mean, some of these laws and regulations will be, you don't have to like ratify them per se if you're thinking about like sort of like international treaty, and then for that to become kind of domestic law, the countries would have to adopt certain laws, so they would go into effect. So it's kind of that interesting kind of quasi-international public law regime in the EU. And thank you for explaining that to us, because it's not immediately clear when you're looking at all these laws and regulations in the EU, what kind of legal effect that might have. And this is very interesting that this is directly applicable on a national level, as opposed to countries would have to take another step to actually for these regulations to become national laws. And just also to emphasize our favorite piece of legislation, the EU AI Act, as you mentioned, is just one of those.
Good luck to national judges with this one, by the way.
So they will be having fun with this one, I guess. The judges in the national courts, right?
Absolutely. Alisa, if I may make one follow-up remark, which may be interesting
Sure.
to you and the audience today, with respect to how complex the legal system is in relation to one big, very important case, Meta Platforms. And you may have seen it. It was the ruling was rendered about a year ago, over a year ago, and it basically concerned the following. You may have read about the decision adopted by the German Competition Authority, which basically found that Facebook's, now Meta's, data-related practices in terms of how Meta would collect and process personal data was an abuse of dominant position. So in US terms, a monopolization case. And it was a bold decision in the sense that the German Competition Authority took into account that the consent that was extracted from users was not GDPR compliant. It was not compliant with the GDPR. And therefore, the decision was largely based on that specific aspect. And basically, after the German Competition Authority established that Meta was in a dominant position in the German market, because it was exploiting users the way I described by extracting a consent that was not GDPR compliant, was violating German competition rules.
Here we go.
So Meta appealed, after many different courts. Eventually, the case reaches the Court of Justice of the EU, which basically, the process goes as following. It's called a reference for a preliminary ruling. The national court in these complex cases, especially platform regulation cases, decides that, I don't have the answer to that. There is no precedent for that. I need to ask the Court of Justice of the EU for some guidance. The Court of Justice of the EU in that specific case, yes, a competition authority can take into account whether rules such as the GDPR have been infringed when determining that an abuse of dominant position has occurred. It provided guidance to the national court, and then the national court can basically render its ruling. This is how complex the EU legal system is. And in those cases, the precedent of the Court of Justice of the EU will indeed be binding on national.
Yeah, this is this is very interesting. Thank you for unpacking that. Yeah, and the GDPR, I'm sorry, is also a very important piece of legislation. And I think that since 2018, we just kind of all got used to the rules, and we kind of understand more or less. But if you could talk a little bit, maybe that would be the good segue regarding the enforcement, and what are the points of failure maybe in the GDPR, and what kind of resources that regulators may have kind of to pursue those kind of cases, if you wanted to talk a little bit about that. Because I think that right now, there's a lot of talk about Meta and other companies that are actually using the data.
I was gonna actually, that was my question. Not even question, but I just wanted to kind of bring up the GDPR, because it's a very comprehensive piece of legislation, and it's the first of its kind and all the good stuff, but it's notoriously hard to enforce, and it literally takes years for the investigation and the decision to be available. And I wonder, has the has something changed with the DSA and the DMA? I mean, we've already seen kind of some moves with regarding the DSA, right? Some platforms that literally they were already they're fined, I believe, a certain amount of, and the DMA they've already designated like 22 gatekeepers, right? The very big platforms and companies, but kind of were there lessons learned, or is it too early to tell from the
Oh, these are
GDPR
all
and kind of
excellent questions. Where do I begin? Let me start from the GDPR.
another hour,
Excellent.
maybe?
Excellent questions. The hour will not be enough. No, it's not going to be enough. So, with respect to the GDPR, I think that you raise a very interesting aspect, that of enforcement. And of course, the GDPR can be or can be seen as a story of as a success story, but also as a failure story. And I will explain why. A failure story in the sense that we have not seen the enforcement we were expecting to see. So, the GDPR establishes obligations not only for digital markets, right? If you go to the supermarket and you're asked to fill out a form, that's basically processing of your personal data. So, the GDPR has a broad field of application, a broad scope, and of course, it also covers digital technologies and the way our personal data is processed by platforms in our case today. However, one of the big rules concerns consent. And this is where I find a lot of tension between, the DMA and perhaps competition law and the GDPR. The GDPR uses consent as the golden standard. If consent is informed, unambiguous, and so on, then it's freely granted, then it's fine. However, in digital markets, I'm not sure whether this whole concept of consent really works. First of all, because we all suffer from what is known as consent fatigue to begin with. And secondly, because consent has been extracted in so many different ways that try to exploit us, we don't even necessarily know what we consent to. And therefore, the concept or the normative standard of consent as one of the legal bases set by the GDPR under which platforms can process our data is, I think, faulty in many different ways. And there have been decisions to that effect, right? And of course, a lot of empirical studies that, explain exactly what I just said about consent fatigue and the way consent is extracted. With respect, now that's about the substantive aspects of the GDPR or some aspects. With respect to enforcement, I think that one main issue with respect to the enforcement architecture of the GDPR is the so-called one-stop shop principle, which means what? If I'm a company and I'm based in Ireland, as many platforms are, that means that the Irish Data Protection Authority will primarily be responsible for monitoring compliance with the GDPR. But if I'm a small country, and if I have a small data protection regulator with specific, very limited resources at my disposal, and of course, the national regulator also needs to comply with the rule of law, as opposed to many of these platforms that, in many cases, think they're above the law. They need to gather the evidence, draft very lengthy decisions that will be appealed in any event. So, enforcement of the GDPR, because of the one-stop shop principle and because of very limited resources given to, regulators across Europe, are the main weaknesses, drawbacks of the GDPR enforcement as things currently stand. And I believe I saw an article a few months ago where an EU official was basically explaining that this one-stop shop principle needs to be amended and we need to streamline the enforcement process of the GDPR. So there are so many different issues that your questions raise, but of course, with respect to the enforcement aspect, this is where the GDPR under-delivered. Where the GDPR was perhaps a success story was with respect to companies that wanted to comply with the GDPR. So you may have read Anu Bradford's The Brussels Effect book. And there she explains that, companies that have a global footprint are active in many different markets. They have two different choices in terms of compliance. They can either choose to comply with the rules of each specific jurisdiction, or they can choose the strictest legal standard and comply with that strictest legal standard to basically reduce compliance costs. And many companies have decided to implement the GDPR standard because this is essentially the strictest privacy standard that exists at the moment in order to reduce the transaction compliance costs that compliance with different privacy rules entails. So I think this is where the GDPR was a success story. But if I may make one final remark, which relates to your point, Elena, the implications of the DMA, the DSA, the AI Act for lessons on enforcement. The GDPR, as you said, establishes many stringent rules. So a lot of people raise the argument, well, why do these rules need to apply to every company that processes personal data across the board, to the effect that it increases significantly compliance costs of smaller companies, whereas big companies that do not necessarily comply with it and do not necessarily have an active regulator that will go against them for whatever reason, basically get away with it. And therefore, there is an imbalance in enforcement. And I think that what we tried to do with respect to the DMA was to address some of the weaknesses of the GDPR by establishing stringent rules that concern the processing of both personal and non-personal data, but also by granting or by creating a system of centralized enforcement. So with respect to the DMA and the DSA, you correctly pointed out that there have been cases already by the European Commission. The European Commission is the authority that is primarily responsible for enforcing these rules, okay? And then it may be assisted by national regulators or national competition authorities, but then the European Commission is basically the decision maker in these cases. And this is one lesson that we learned from, I think, the GDPR, but also from competition law. With respect to EU competition law, the way things were at the beginning is that we had this European Commission that would decide on pretty much everything, but we didn't have national competition authorities at all. After enforcement experience was gained, and a substantive amount of case law was created, we decided to decentralize that and create national competition authorities that would be responsible for each domestic market. So here we try to do it the other way around, or at least the same way as we did with competition law, so that we centralize enforcement, we produce some decisions, and then perhaps at some point we decentralize that enforcement aspect.
It's really, really fascinating. I mean, I knew that 1 hour wouldn't be enough, but since I usually tend to just hijack the topics we talk about, I'm gonna do just that right now. I mean, I cannot not ask this question since we have you here, Konstantina. So we all have heard and obviously read, everybody's been talking about that the US innovates, EU regulates, EU is shooting themselves in the foot with all those regulations coming out of it. Oh my God, what are you guys doing? Big mistake, big mistake. And I'm seeing those gleeful comments and posts like, oh, Llama 3 is not coming out of in the EU. It's not available to you guys. Ha ha ha, 18 more months, wait. And the recent OpenAI advanced voice mode, obviously not available in the EU as well. And people are very, very happy about it here. So, and in the light, especially in the light of the recent Draghi report, right? Because people are talking about it. I mean, in my bubble, at least, of people who are interested in the EU policy. And for those of you who don't know, so the Draghi basically report says that if the EU doesn't kind of claw back some of the regulation that already is out there, we are in big trouble and we won't be able to just be competitive, and no innovation. It's going to stifle everything, basically, just end of days and very, very much depressing things will happen. So what's your take on this? I would just really like to know.
That's so dramatic. No,
Hamletian style dilemma, Konstantina, I would say, is like to be or not to be, innovate or regulate.
Regulate or not to
reason, yeah, for some reason, these are really become like this extremes kind of a sides of the spectrum. So yeah, I just wonder, I mean, I guess it's a rhetorical question where there could be a balance, but I mean, yeah. So I mean, I'm on a side of like regulation. I'm not I'm not
I
scared that we were going to miss out on any innovation at this point. But again, I mean, there are many people in the other camp who completely disagree, especially here in the, I think, in California and Silicon Valley. So yeah.
Of course, and in some cases, in with with some very few exceptions, I understand the point of view. However, clearly, I am pro regulation. I personally believe there was a big gap in the legal framework, as I explained at the beginning of the presentation, that we somehow had to fill. I mean, consider the amount of disinformation that is available out there. Consider the terms and conditions that we need to accept as consumers when we use these online platforms. These were not addressed by the legal framework. There was nothing to address these practices other than horizontal rules that applied to everyone. And if there was a case, that would be an ex post enforcement case, right? One decision binding one company for one practice. There was clearly a gap in the law that had to be filled. Let's start with that. Secondly, some of these rules are very sensibly drafted. Let me give you the example of the Digital Markets Act. The Digital Markets Act, yes, it imposes certain obligations that will force certain platforms to change their business models, their commercial practices, contractual relationships, and so on. But the DMA does not apply to everyone. It applies to a specific set of services, a specific set of companies that act as gateways for businesses to reach end users. This is why we use the term gatekeepers, right? The same applies to the stricter obligations of the DSA that only apply to very large online platforms, meaning companies that reach 45 million recipients of service within the EU, and very large online search engines that basically are bound by the same threshold, meaning to qualify as such, you need to have 45 million recipients of service. By the way, for a company to qualify as a gatekeeper under the DMA, it needs to reach 45 million monthly active end users. So these are big numbers. These rules do not apply to everyone. They apply to a specific set of companies, specific set of platforms. This is where, since Alyssa wanted to talk about EU law, this is where the principle of proportionality comes into play, which is a general principle of EU law. We don't regulate everyone when there is no reason to regulate everyone. We regulate only specific companies that engage in a specific set of practices. Thirdly, when we discuss innovation kills competition, regulation kills innovation or regulation kills competition, I don't agree with the statement at all. I am yet to see any empirical studies proving that, by the way. And also, I think that when we dig deeper into the real reasons for why there is no Google EU equivalent, for example, we will find out that there are different reasons, meaning strict bankruptcy laws. If you go bankrupt in the EU, good luck getting a second loan from a bank. Secondly, and that's basically for many people that are outside the EU and do not necessarily understand the culture of the EU member states or the dynamics, this is still a very fragmented market, guys. It's not like the US where everyone speaks the exact same language and you can communicate with one another. And once a product or a service becomes successful, boom, it scales, it becomes super popular. And therefore, the company can basically expand its services or its operations beyond the US frontiers. The EU has many, many languages. And that is a very big barrier to companies that want to scale with their product or service. Okay, you may have seen that with the AI models, with LLMs, basically, and how difficult it is to create, a bot that will give you conversational answers in Slovakian or Slovenian. So that's a big problem. Therefore, to put it very simply, in my view, first of all, we needed regulation. Secondly, there are so many reasons that stifle innovation in the EU that have nothing to do with regulation. And thirdly, and this is always the concluding point that I use when I give an answer of the sort, it's basically a value judgment. What kind of society do we want to live in, and why do we say that regulation kills innovation? Let me give you one example: the Digital Services Act. It includes a very broadly drafted yet very useful prohibition whereby online platforms should not design their user interfaces in a way that manipulates end users, in a way that deceives end users. Why would that obligation or prohibition kill innovation? why shouldn't platforms of any size be bound by an obligation of the sort? So I think that when we talk about specific rules, we also need, or regulation more generally, we also need to understand there is a value judgment behind those, in the sense that we expect platforms or other digital service providers to behave in a way that does not harm society.
Yeah, thank you for mentioning all this, all this diversity of cultures and languages in the EU, because I think this is definitely that, sometimes maybe people don't really think about, or maybe they forget, or don't pay they don't maybe necessarily think of that as a very significant factor. But you were, yeah, you were talking about, kind of European Union thinking about where, how the society, how we want to move forward, what our values are. And in that regard, I was thinking, because in the US right now, there is this big discussion about, how you're going to be regulating, media, for example, media platforms, and how that interplays with the freedom of speech and freedom of expression, because this is the one of the pillars of our, constitution. And actually, there was a law just signed in California regarding AI, deep fakes and things like that. And people are already concerned that this is going to go into to stifle, freedom of expression and freedom of speech and things like that. So I was wondering what your thoughts are on, DSA or DMA. I mean, these are all newer laws, but do they even cover, that realm of, generative AI, or whatever? Maybe they're already outdated. I mean, what are your thoughts in that regard?
Absolutely, absolutely. And I think that's an excellent question, in the sense that, it just shows how technology regulation should be drafted. And when we talk about the drafting of technology regulation, I guess you have, broadly speaking, I'm oversimplifying now, I understand that. Broadly speaking, you have two choices. You either draft rules by adopting a principles based approach, broad rules that will then be interpreted by the courts, or you follow a more narrow minded approach, meaning you go after specific practices based on what you have seen in the market, right? The DMA and the DSA follow the latter, in the sense that they try to focus on specific practices and specific issues that we have been seeing for many years. That being said, even when you adopt this narrow minded approach, which in many cases is good because this means that these rules can be enforced from the outset, you try to define the different services that will fall under the scope of the regulation. And there you need a legal definition that cannot be very broad, because you want to make sure that you're proportionate, right? That you follow the principle of proportionality. So, with respect to the DMA covers a specific set of what we call core platform services. That includes search engines. Let me take the example of search engines. I'm not sure that all generative AI tools that we use at the moment would qualify as online search engines for the purposes of the DMA. Why? Because the legal definition of the DMA refers to general search engines, okay? And that definition refers to the ability of being able to search all websites. Some of these tools do not even have access to the internet. They have been trained on data from the past, and they don't, search the internet as they produce an answer. Some others do search the internet and provide an answer to the user's query. So I think that, these definitions were not drafted with generative AI in mind, because these rules were proposed and adopted before the revolution of generative AI. The same applies with respect to the DSA. So, online platforms are essentially hosting services. Then you go and check the DSA and the legal definition of hosting service in the DSA. And basically, a hosting service is a service that hosts content provided by the recipient of the service at the request of the recipient of the service. I'm not so sure that, content creators grant or make a request to these tools for their works to be used by these tools and then produce an answer that is provided to end users. So, there are gaps even in the newest rules that we're discussing. And that makes me wonder as to whether, there's already a gap in the framework that needs to be addressed. But Alisa, I think that one important remark to make here is that, these rules have only been adopted, have been adopting just now, and they will start to be enforced. And these regulatory instruments that we talk about, the DSA, the DMA, will be reviewed in the next couple of years. They have this review clause embedded in them. And therefore, this allows for these technological developments, revolutions to be taken into account when there is a review. So I think that if there is any ambiguity at the moment, this will be addressed in the near future. And of course, with respect to the second leg of your question, freedom of expression, I mean, that is a very difficult balance to strike because, we need to consider the two sides of the same coin, right? You have freedom of expression of whoever wants to post something online. But I, as a citizen, at least in the EU, have the right to receive information. In fact, I have the right to receive impartial information because the system has an obligation of the sort imposed on media service providers and more recently, partly on online platforms. Therefore, what about my right to receive information? And one thing that is worth mentioning here concerns the case law of the European Court of Human Rights. So, freedom of expression, as you know, is not an absolute right. Restrictions on freedom of expression can be imposed, to the extent that those restrictions are justified and proportionate. So, I think that this is going to be a balance that is very difficult to strike. Nevertheless, I also think that when we discuss regulation of deep fakes or, bots and everybody posting whatever they want online, disseminating misinformation, we also need to consider that citizens need to have access to the right information to be able to make informed decisions.
Sorry, I was also trying to unmute myself. Yeah, this is definitely a much larger topic, and I don't think we'll have an answer. I think it's just kind of a work in progress, and that's, how we can balance those things out, and also depending on the country as well, because in the United States we have this one regime that people are thinking, also depending what, I guess, their party affiliation, sometimes how they approach the boundaries of free speech and freedom of expression. So yeah, it's going to be interesting how that is going to play out. It's just for us this year, this issue is very, very pressing and crucial because we have presidential elections coming up and in a few weeks. So yeah,
And this is also, Alisa, this is a very good point to make. And this is also where, the right to receive impartial information comes into play. And I think that when we discuss, online markets and online media markets specifically, of course, we acknowledge the role that online platforms play in disseminating more easily, more broadly information that is of concern to the broader public interest. Okay. But we also acknowledge there is a role to play for traditional media, meaning media that are subject to, regulatory rules, strict regulatory rules, and traditional media that, are accountable for the content they distribute vis-a-vis regulators. Not all platforms are regulated at the moment, and not all platforms have a regulator they're accountable to.
Yeah, I think that could be another talk in itself, right? Our third kind of talk point. And I just wanted, since we're getting to the kind of the end of an hour, I just really wanted to switch quickly to again, larger topic of regulating generative AI, whatever that means right now, kind of in the EU for in the realm of competition law and DMA, DSA, AI Act, maybe some copyright regulations, like how all of that is playing out in your view, in terms of like, because we're talking about,
you have 7 minutes,
right?
Constantina.
Yeah. If we're thinking about models, let's say as products, right? Or AI models, or in some other, so I know the large question, but if you could kind of quickly share your thoughts on
yes.
that. Well.
So I'll try to be very quick in the sense that we see many different initiatives, right? You outlined most of them. What I like to see is the initiatives taken by competition authorities. And I will explain why. With respect to online platforms, as I mentioned, we did things the wrong way for many, many years, and then we decided it was time to change. And many competition authorities, including the European Commission and some ambitious national competition authorities, decided to initiate these controversial cases. But starting an investigation and adopting a controversial decision is not the only tool that a competition authority has at its disposal. It can basically conduct what we call sector inquiries to understand how a sector works before it takes any enforcement action. So that brings me to the first point I wanted to make, which is that many competition authorities across the EU, including the European Commission, have taken initiatives to understand how generative AI markets work in practice, identify the bottlenecks, the risks, and perhaps take enforcement action when necessary. Meaning we're not doing it the wrong way, we're doing it the right way, at least for now. The other point that I wanted to make concerns the DMA. The DMA, as I mentioned, is not clear in terms of whether it regulates generative AI, because it only regulates a specific set of services, and it's not clear at all at the moment whether generative AI would fall under one of these definitions, including the definition of search engines. However, the DMA imposes rules that apply not only to the services for which gatekeepers have been designated, for example, Google Search, but also to many services that the gatekeeper provides. Let me give you one example which may be relevant to generative AI. There is a prohibition in the DMA, Article 5.2, which basically says that gatekeepers cannot combine data sourced from many different services, meaning Google Search, in our example, and many other services that Google offers, unless users grant a GDPR compliant consent. So there are very clear obligations and prohibitions in the DMA that cover services that go beyond the original or primary scope of the DMA. With respect to the DSA, very important issue. As I mentioned, it's not entirely clear whether generative AI tools would qualify as online platforms, but of course, many of the provisions of the DSA in terms of content moderation, removing illegal content, for example, would apply to generative AI tools and should apply to generative AI tools. With respect to the AI Act, one provision that I find particularly relevant, because it is linked to the copyright point that you raised, is this newly established obligation in the newly enacted AI Act, whereby generative AI tools would need to provide a sufficiently detailed summary of the copyright protected content they use to train the model. What that means in practice, Alisa and Elena, we do not know.
Wow.
We'll see.
That's what I can say.
Exactly.
But at least, because there is a big discussion among content creators at the moment. How do we protect our content if we do not know how our content is used? Supposedly, the AI Act takes a step back and says, okay, I will give you transparency, and then you can use copyright regulation. In the EU, that would be the DSM Copyright Directive, to enforce your rights against generative AI tools. So there is, there are both horizontal rules and sector-specific rules that apply to generative AI. And now the only interesting thing that remains to be seen is how these rules will be enforced.
Fascinating time to be a lawyer these days. But okay, if you're interested in all this, tech and the interplay of all these different areas of law as well, because I think that in the United States, we've also been talking like, do we need new regulations? Do we need like federal law? Do we need state laws? Maybe the laws that we already have, and they kind of cover, they might cover this technology already. And we also have these executive agencies, and one of our favorite ones is the Federal Trade Commission that's been very active in that realm after the presidential executive order was issued, right? And they kind of gave the authority to a laundry list of executive agencies to actually, come up with the rules and regulations and enforce the existing ones. So this is very interesting to me. It feels like, I don't know whether I'm a proponent to really stringent proponent of let's have this AI regulations just specifically for these AI tools, or let's just, take the laws that we already have and just going to try to see if they already apply. So again, I mean, striking that balance is just kind of difficult. But because in the US we don't have the federal AI anything. So at this time, it's just a patchwork of things because the states are adopting new laws. So yeah, I'll be really curious to see if this, the Brussels effect again, will be the impact on how quickly our legislators move
That's going to
forward,
be very interesting to see.
or
Yes.
they do not, again, because we rely on the courts as well. That's why we have this slew of lawsuits right now that are heading to trial since last year, and we don't really know. We kind of get a glimpse of here and there, what kind of claims are being dismissed and the kind of trial motions right now by the judges. But yeah, it's going to be, in terms of when they're talking about enforcement, what actually is going to, what's actually how it's going to look like, right? For yeah, and also for the content creators, as you were saying, because people are suing big companies for using their content and things like that. So interesting.
I
Yeah.
am hopeful for the US too, in the sense that the balance will be found at some point, and I can see, the DOJ is taking some very interesting initiatives. So
Yes.
I'm really hopeful.
Yeah, because our antitrust, yeah, I mean, we've seen some really big antitrust kind of a trends right now, and Department of Justice taking action in that regard against big companies, because yeah, I think that EU antitrust regulations are very, very different from the ones in the US. I'm definitely not an antitrust law expert, but I kind of on a high level, I can see that there is more. I mean, in the US, it's kind of a more lax, as you mentioned, the bankruptcy, for example, or some other things that are in the United States. It is very different. So yeah, I think we are. Yeah, I think that we're kind of at the conclusion of our talk. So if there are any concluding remarks you would have, just kind of a summary to provide. So it's
I
just so
think
interesting.
Elena wanted to ask a question, or perhaps even
Yeah,
make the
sorry.
conversation herself. Go ahead, Elena.
you, you see me anxiously muting and unmuting myself.
Go for
Yeah,
it.
no, because I just saw we were at time, but still, I'm just gonna say it. The FTC, right? Our beloved federal agency. So since we're on the topic of the existing regulation and how it might apply, and that's what essentially the FTC is doing, right? The unfair and deceptive practices. Here you go. They just slapped like 5 or 6 companies yesterday with their enforcement actions. The companies that are essentially using AI to just deceive consumers and get the money, and just pretty much it's AI washing in its finest. And I think it's amazing what they're doing, because in the absence of pretty much any type of regulation and enforcement to begin with, I think it's the right way to go as of right now. What's going to happen in 6 months, nobody knows. But Elisa mentioned the several bills that were signed by the California governor last week, right? And how fun it's going to be. It's already fun. They've already been challenged in court on the ground of their constitutionality, right? And again, it kind of feels like 2 steps forward, 5 steps back a lot of the times when it comes to AI and AI regulation. And as we talked about that yesterday in our prep call, Konstantina, right? And we talked like, how do you regulate the moving target? Literally, you don't really know where things gonna land tomorrow, but nevertheless, as a regulator, you have this obligation to do stuff and be proactive, right? And preferably have some positive results, which is not always the case. But people are making some tough choices, and I'm not even talking about lobbying part of it as well, because that's a huge problem in and of itself in the EU and in the US, obviously. But that's kind of the topic for a different hour or two.
But if I may, that's an excellent concluding remark with respect to the issue we're discussing here, because the EU is not the only jurisdiction in the world that wants to do something about this topic, right? And when you don't have the tools, the specific tools at your disposal, you need to find a different way. And the different way is horizontal rules, antitrust law, consumer protection rules, and the likes. So I think that, that would be an excellent suggestion, I think, for smaller regulators or regulators that do not necessarily have the tools at their disposal, is your suggestion that they just need to go for it? Because even if it takes years, they will at least produce a decision that is at the cutting edge and that will have helped consumers that may not necessarily have had the opportunity to find justice. And even though justice delayed is justice denied, sometimes some ambitious regulators need to do this. The Google shopping decision, it took the European Commission so many years to adopt a decision. Then, of course, there were appeals and appeals and appeals. So, the process takes long. But I think that in a rule of law jurisdiction, this is something that we need to take into account. The important thing is to do something about it rather than sit on it.
Yeah, no, I absolutely agree. Even like those the complaints and the lawsuits and all those enforcement actions, even if it's not going to work on all the companies who are contemplating using AI to deceive people and do nefarious stuff, right? It's a good deterrent for a lot of other companies. They're gonna think twice before they even start, So I'm all for it. On that positive note.
Wonderful note. On that positive note.
Right. Yeah,
Thank you so
Konstantina,
much.
thank you so much. Yeah, I learned a ton. I think that I was in law school, I probably should have taken like antitrust, law class, because it is very interesting, especially in the US now that we have like just a bunch of really big guys, like a few huge players that are dictating the vibe and the trend and kind of the rules, and writing open letters to Congress and to people. So it's I would like to see some sort of order there. So it was really interesting to learn more about the EU regime and how it's going to play. And I think it's important also for people and lawyers and law compliance, also professionals, to understand that if you're going to do any business in the EU, and I think people are thinking about that already, what you could be facing, right? What kind of regimes you could be facing, what kind of regulations, and things like that. So
Lisa, that's a very important point that we need to clarify. Actually, we discussed it with Elena yesterday, and with that we can conclude that all these rules were established and were adopted in a very sensible manner in the way their geographic scope was defined. So it's not about where the platform in our example is established. It's about whether the consumers and the businesses that the regulation seeks to protect are established or located. So that's very important to consider, in the sense that the EU can only clearly regulate its own jurisdiction, its own boundaries. We go back to principles of public international law, but it's very important to consider, that there is an existing very complex regulatory regime in the EU. Whichever company wants to do business in the EU, it needs to take into account these rules when it comes to
because they're targeting essentially consumers and businesses, if it's a B2B business to business solutions or platforms. Thank you so much, Konstantina. We don't want to hold you any longer. We're kind of over time already.
In the background.
I just wanted to say thank you so much for joining us, and we just wanted to let our audiences know that our next talk will be in a couple of weeks, and we will again have fabulous speakers from the UK, actually, from Alan Turing Institute. We're going to be talking about those initiatives. So thank you so much, and
Thank you.
Thank you for the invitation. It was a real privilege, and I wish you all the best. Thank you so much.
Thank you.
Bye.
Bye, everyone.
Bye, everyone.